Your Worships, this is my application for an adjournment, which I know my friend for the prosecution agrees with. As you may be aware, my client faces a serious matter, and it may in due course be heard at the Crown Court. Briefly, the situation is this. My client was one of a number of men outside a nightclub in the city centre when a violent incident took place. This appears to have been a fight with two opposing factions involving up to 20 people, some of whom may be potential witnesses once the police have confirmed their identities and have spoken to them. There are 7 police witnesses, 6 civilians who have made statements at this time, although I only have a summary with regard to most of them. This is a complex matter involving the alleged use of a metal pole by my client, and there are a large number of potential witnesses for the defence to be seen, and I simply cannot take full enough instructions on the time available to me today to advise my client as to plea and venue. My friend for the CPS has confirmed that there is CCTV evidence and the Crown will be relying upon that evidence and are therefore under a duty and are bound to serve it as part of the advance disclosure. Your learned legal adviser will confirm that this point was established in the Calderdale Justice's case. My client and I need to view this. If he is forced to enter a plea today, I would have to advise him to plead not guilty, whereas the adjournment I seek will clarify the issues and a guilty plea may be forthcoming, therefore saving much time and expense.
Your Worships, we agree. This is a very complex matter and there may be further people charged in due course. The lawyer dealing with the matter at the CPS wishes to further review the evidence and we support the defence application.
But surely you could take sufficient instructions to deal with plea and venue?
Well, with respect, Mum, this is not the straightforward case that CJSSS envisaged. And my client's rights under the Convention would not be served by me rushing into important decisions, armed only with the briefest of information and instructions. I require only 2 weeks, which will not cause any particular undue delay, especially in the light of what my friend for the CPS has just told you. I would respectfully, Ma'am, ask for a 2-week adjournment so that the CCTV can be served, I can view it, I can take my client's full instructions and be in a position to properly advise him as to plea and venue.
What do you say to this application, Miss Vale?
I agree with the application, Ma'am. As my friend has rightly pointed out, substantial inquiries are ongoing and I'm aware that a colleague has viewed the CCTV. It is highly relevant and this will be served on the defence as soon as possible. I would suggest that to ensure that everything is ready for the next hearing, you might wish to consider a 3-week adjournment.
Mrs. Bardell, am I right in thinking that CCTV evidence which the Crown relies on is disclosable to the defence?
That's correct, ma'am, and the case of Calderdale Justices is the authority for this.
We feel that the application for an adjournment is one that has considerable merit and we're minded to grant it, subject to further advice from our legal adviser.
Ma'am, the question of an adjournment is a matter for yourself and your colleagues, as long as you have applied the criminal procedure rules. May I point out at this particular stage that the prosecutor have already supplied the defence with a bundle of the evidence, which, as you would suspect, bearing in mind the defendant has been charged, does in fact show a case against him, and also mentions the number of witnesses who can give evidence as to what happened. Even if the CCTV relied upon and is disclosable to the defence, it is not the case that all the evidence has to be served before a plea is taken. As you are aware, a summary of the case can suffice. The Calderdale case is certainly not the authority for saying that a court must adjourn a case even when the CCTV, which is relied upon by the Crown, has not yet been served. You may feel the guidance from Lord Leveson in 2009 is appropriate in this case, and bearing in mind that a plea not taken on the first occasion should be very, very rare.
Well, of course, it's helpful to everybody that the prosecution complies with the responsibilities in accordance with the guiding principles of CJSSS. And we do have some sympathy with the application on the basis of the advice given by our legal adviser. But we confirm once again that the court must take the defendant's plea at first hearing. That obligation doesn't depend on the extent of the initial details of the Crown's case, service of evidence, or disclosure of unused material. There's nothing especially unusual about this case, and we do require a plea to be taken. If the pleas are not guilty one, a decision will be made about venue.